I'm so pleased to see so many here this morning. As many of you already know, October is Domestic Violence Awareness Month. The impact of domestic violence affects all of us in so many ways, whether it happens to a family member, a co-worker, a friend, or a stranger. The devastating effects can also leave a significant impact on a community. I first became aware of the need for a change in the law when a constituent phoned during the Kerry campaign and said that she wanted to vote, but was afraid to have her address known because of fear of her ex-spouse. At first, I thought this could be taken care of through an administrative change. When I phoned the Secretary of State's office, I found out that this could not be done administratively, but would require a change in the law. Then, at that point, I decided to go ahead and request a bill be drafted in November of 2005. Secretary Brunner has taken the lead in doing research and helping to craft the legislation so that not only will this allow a person in fear for their and their children's safety to vote, but it also will allow and provide for greater protections to those who live in fear. The other experience that I've had that still troubles me a great deal is a case of a young man coming to me when I was mayor of Kent in the early 90s. He complained that he was being stalked by another man. He had moved several times and had a protective order, but that didn't keep his stalker from finding him. Several years later, it was announced that he had died, and I believe that he had committed suicide. Certainly, we've come a long way since then. It is hard to imagine living day to day, fearful that a perpetrator might discover where they live and to worry about harm to themselves and their children. Although we cannot guarantee a person's safety, this bill goes a long way in providing a greater comfort to victims. Ohio has a real opportunity to modernize the way we try to protect people who are in danger, who have been threatened, and who may be defenseless. 37 states have already adopted programs that shield the true address of an endangered individual's residence, workplace, or school. Abusers in these states are no longer able to track down their victims using information that they find in the public record. It is time for Ohio to step up to the plate and provide a way to secure peace of mind to those Ohioans. I've been working with Secretary Brunner for a long time on legislation to create an address confidentiality program, and today the bill is almost ready for introduction. I cannot tell you how thankful I am that Secretary Brunner has been such a supporter of this legislation. She has done a tremendous amount of work and has done a lot of research, and I believe that we have a really good bill coming forward. I thank all of you for coming today to hear a little bit about what we can do to protect victims of abuse and their children so that we can try to have a safe, so they can try to have a safe and normal life.
We have been working laboriously on the draft of the bill, and the bill is, we have another version of the bill, and it is near ready for introduction. I can speak from my own personal experience. Having been a common pleas court judge for nearly 5 years in Franklin County, one of the duties that any judge at the General Division has in our court here in Franklin County, when you were the duty judge, your job was to hear civil stalking protection orders. And those orders are given fairly frequently by the courts to not just women, but men and even to young people who are being stalked or harassed by someone else in their life. The precarious position that the person is in that situation is, first of all, they need to be remain safe until that order, once granted, is served by a sheriff upon the respondent in the case, and then that goes through a full hearing in Franklin County with the magistrate, and then the judge that issued the original temporary order eventually signs off on it. There are other orders given by the domestic relations bench as well. The difficulty is, though, that the things may happen that law enforcement can't react to quickly enough. And so this is a way to prevent the person who is the victim of abuse from being able to be found very easily by their stalker or by the perpetrator. When I was campaigning for Secretary of State in 2006, I became aware that many other Secretaries of State had carried out this function in their states. And I thought originally that could be a lot of people. But when you look at states like California, it's really a very manageable number of people. Now, as the bill is drafted in one iteration, it involves a requirement that the person actually work through an application assistant who is appointed either by a court or by the Secretary of State. And if the Secretary appoints someone, it's someone who is actually working at a domestic violence shelter or prevention program. And in that case, the application assistant, much like what we see in the court system where someone is seeking a civil stalking protection order, actually sits down with the applicant and assists them in filling out the paperwork to make this change. What happens then is that that person's mail is then sent, that person's official address or public address actually becomes a P.O. box established by the Secretary of State. And any government agency would be required under the law to abide by that address and send documents to that address. The Secretary of State then forwards that mail on to the person at the address, which is what we call their true address, where they can be found. In that case, the actual address of that individual is not a public record, but it can be obtained through a court order. In such a situation, the individual would need to work with other people who send in mail to use that address, and that registration is good for a period of 4 years and is renewable. If the individual changes their name, they would need to re-register again, and if they were to move without leaving a forwarding address within 14 days, they would be canceled from the program. This is, when it comes to registration and voting, one difficulty for an individual is there are a number of individuals who, for fear of their safety, do not register to vote because their address, their true address, is required to appear in the public records. And if you think about the Help America Vote Act, which now requires Secretaries of State to maintain statewide voter registration databases that are accessible through the internet on the website of the Secretary of State to the public, this does put some people at risk. So in this situation with registration and voting, the person registers with the Secretary of State. This is an address confidentiality program ballot that they receive, which is basically an absentee ballot. And when the person sends their, and they can only vote absentee, when they send their ballot back to the Secretary of State, we're requesting that the persons who handle it take an oath, and the law as prepared at this point would require that it be a bipartisan team. They would verify the identity of the person. They'd still be subject to voter identification requirements that everyone else is. And then the Secretary of State would remove the identifying information and forward that ballot on to the appropriate Board of Elections. One of the reasons why this took quite a bit of time to get to this point was looking at the logistics of what would be to protect the safety of the person while at the same time protecting the integrity of the process when it comes to voting, and at the same time not creating an excessive burden for the individual boards of elections. And we looked at doing this a number of different ways, but this appears to be probably the way that best meets all of those needs involved.